Welcome friends, we are discussing different chapters on corporate tax planning, and in this session we will discuss on the appellate procedure or appeal proceedings, revision proceedings under the Income Tax Act. In the assessment chapter, we have understood the basic procedure of determination of the income and confirmation of the same by the department. It may be a normal prima facie assessment, it may be a scrutiny assessment, it may be a income escaping assessment, it may be a best judgment assessment, as the case may be, as the situation permits. But the Indian Constitution or the legal framework always provide an opportunity for the assessee to file an appeal, to prefer an appeal before the higher authority if he or she is aggrieved with any of the decision of the assessing authority. In other words, if the assessing authority disallowed certain amount of income or disallowed a certain amount of claim or deduction, the assessee has got a right to file an appeal challenging that particular order to the higher authority. In this case, the higher authority, say Commissioner of Income Tax Acts. Correct. Now, there may be two or three situations that may arise. Situation number one, an assessment has been completed and the assessee is aggrieved. The assessee is not happy with that, with the different adjustments the assessing officer made. He may go to the appeal under 246 capital A of the Income Tax Act. He may also go to the senior of this assessing officer, to the commissioner, requesting him, sir, I have been deprived with this particular benefit of deduction, and the commissioner, he may appeal before him under section 263 of the Income Tax Act simultaneously, wherein he can say, sir, my order is not very clear to me, 264 may please be invoked, and in this entire proceedings, we are not going into 263, 264, we are just restricted to 246 capital A of the Income Tax Act. What this proceeding says, what this procedure says, the assessee need to first find it out why he or she is aggrieved. What are the reasons? Whether certain income which is not his income has been added, certain allowances which legally or legibly he claimed has been disallowed, certain TDS certificates or certain advance payment of tax which he or she has actually paid, never considered, or the assessment order itself is impugned, it's debatable, is not very clear, there are a lot of ambiguities, and certain income which has not reflected actually has considered incorrectly by the assessing officer. The assessee can file an appeal before the tax authority, before the Commissioner of Income Tax, or in other cases before the Joint Commissioner of Income Tax, as the case may be, and may file a petition for a correction, for a benefit, for a relief, claiming the relief thereof. And what are the reliefs? The relief may be whatever we have discussed, the certain income or certain expenditure wrongfully disallowed, claims incorrectly disallowed, the tax deduction payment has been incorrectly disallowed, all these things could be covered. The appeal has to be filed. There is also a very important issue that appeal has to be filed in a proper fashion, proper manner, in a particular form, and within a due date, filing with the appropriate filing fees thereof. Now, what is the filing fees? Let's understand what the filing fees is all about. The filing fees says, the question of filing fees says that if the total income of the assessee as computed by the assessing officer is 1 lakh rupees or less than 1 lakh or up to 1 lakh rupees, and the assessee wants to get a relief, the fees payable would be rupees 250 rupees. This is under section 249 subsection 1, and the assessee needs to file the application for petition in the appeal in form number 35 as a prescribed form, giving the ground, giving the reasons why it has been disallowed, and then the ground what he or she is asking, what relief he or she is asking. So that means, say some the 80G donation certificate or properly placed, but the assessing officer disallowed it, giving certain reason or without giving any reasons thereof. The assessee may file appeal petition stating therein that this donation certificate has been, or the claim of donation under section 80G has been disallowed by the assessing officer without citing a proper reasons thereof. He needs a relief, a benefit from the authority. A prescribed form 35 within the prescribed time limit with a prescribed fees. What is the prescribed fees? The prescribed fee is if the total income of the assessee as computed by the assessing officer is up to 1 lakh rupees or less, 250. Where it is 1 lakh to 2 lakh rupees, then it is 500 rupees. Where the total income of the assessee computed is more than rupees 2 lakhs, more than rupees 2 lakhs without any upper ceiling, then it is 1000 rupees. So assessee need to file with a proper form, with a proper filing fees to the assessing authority, appellate authority, within 30 days from the date of receipt of the order. So section 249 says that when the order has been served, then appeal to be filed within 30 days from the date of receipt of the order. Very good. What is the process then? The paper has been submitted. The procedures of filing the appeal is already over. Now the appellate commissioner will take up this issue by issuing a notice. So now the procedure starts. Section 250 of the tax law, Income Tax Act says that the commissioner appeal or the joint commissioner appeal, as the case may be, as it's applicable in this particular case, shall issue a notice telling that you have filed it, I am ready to listen you, hear you with your justification. Please come with the documents, evidences to prove that you have a justified claim which has been denied by the assessing officer. What is the power of the commissioner so far as appeal is concerned? The commissioner appeal or the joint commissioner appeal, as the case may be, has a tremendous power in disposing of the appeal petition. They will listen both the parties, the department as well as the aggrieved assessee, and he may confirm, he may reduce, he may enhance, or he may annul the assessment. So that means it may happen in any way. The commissioner may reduce, may confirm the liability, tax liability, may enhance it, may annul the assessment. He says that it's absolutely perfect order, you go ahead, or he may reduce it, he may delete the disallowances also, right? All the material and other information produced by the assessee before the commissioner need to be heard about it. The inquiry, if anything is pending, however, if there is an inquiry is pending, if the same matter is pending before other authorities, say a settlement commission and others, or in other higher authority of the revisions, the commissioner appeal need to consider that issues before taking a final call. Once the CIT appeal, commissioner appeal is absolutely through about the merit of the case, the fact of the case, heard both the sides, assessee as well as the assessing officers, take a comprehensive approach, a statement that what should have been and what actually had taken place is proper or which is validly applicable, pass an order, that's called the appellate order. Once the appellate order is passed, if the assessee is happy, if he find that all his claims has been allowed, what the disallowance was made by the assessing officer has been turned down, annulled by the commissioner, he may close, he may not further go ahead. If the department also find that this appeal order is good enough, they also will not go ahead and the matter settles there itself. However, in the event if the assessee find that the commissioner appeal has not given him a proper benefit or justification, or the order is not very clarificatory, or in the order a lot of confusions are there, the benefit has not been passed on, the assessee may further claim, right, in the second layer of the appeal called as the appellated tribunal. And the appellated tribunal becomes a second layer of appellate authority where the assessee files against the order of the commissioner appeal. It may also happen that department may also file against the order of the commissioner appeal before the appellated tribunal. What is the tribunal? The tribunal under section 252 to 255 of the Income Tax Act is like a bench, it's a board constituted by the government, central government, appellated tribunal, comprising two persons minimum. One is called judicial member, one is called the accountant member, and these two members take up the cases where the assessee becomes appellant, goes to the tribunal asking for a particular relief under a particular sections within the framework of the Income Tax Act. And they also listens to the justification to the appeal made by the department, where the department, the income tax department, finds that the benefit allowed by the commissioner is not justified. So both the cases is a legal forum now has come called as the Income Tax Appellated Tribunal. The process is almost the same. The application has to be made in form number 36 with an appropriate justification, reasons for the appeal, the ground of appeal with all details, modalities, and then wait for a decision what the judges will take place, the accountant member and the judicial member takes place. If in a case, in a situation where the appellate tribunal, ITAT, Income Tax Appellated Tribunal order is in favor of the assessee, assessee may be extremely happy and he says close the file. Department who is aggrieved, who is not happy, may file further appeal to the next layer, that's called appeal before the High Court. Appeal before the High Court. The same thing also applicable in case of the assessee. If the assessee finds that the order is not favorable, the tribunal has not given proper opportunity of being heard, the tribunal has not adjudicated the issues legally, the assessee may also file an appeal before the High Court, then to Supreme Court. This is the entire process of the appellated revision and the appeal, and then the second layer of appeal, that is tribunal, and then the third layer of appeal, that's called as the High Court and Supreme Court. In between these issues, there may be a revisionary situation. There may be a settlement commission. There are settlement commission, and a revision by a commissioner may take place subject to the provisions of the Act, where it says that if the matter is pending before the appellate authority and not adjudicated, a revision could not take place, because it's like the same issue could not be adjudicated at the parallel level, one in favor, one in adverse. It has to be in a proper hierarchy. Friends, it's the detailed process: filing of appeal before the High Court, then to Supreme Court, filing fees, engagement of the counsel, filing before the particular bench, appearing before the bench, submission of the paper book. It's a detailed procedure, but here in this session we come to a close, come to the conclusion of this session, telling that wherever either the assessee or the assessing officer is aggrieved, is not very happy with the order by the authority, whether it is assessing authority, appellate authority or tribunal, the Indian Constitution permits him or her to go further to the next layer and ask for a revision thereof. Thank you everyone for this particular session, and we look forward for other details in other sessions too. Thank you.